Welcome to the 17th meeting in 2025 of the Delegated Powers and Law Reform Committee. I'd like to remind everyone to please switch off or put to silent mobile phones and other electronic devices. The first item of business is to decide whether to take items 6, 7, 8, 9, 10 and 11 in private. Is the committee content to take these items in private?
Yes.
Under agenda item number 2, we're considering instruments subject to the affirmative procedure. An issue has been raised on the draft Environmental Regulation Enforcement Measures Scotland Amendment Order 2025. This instrument amends the Environmental Regulation Enforcement Measures Scotland Order 2015, the Principal Order, to include offences under the Producer Responsibility Obligations Packaging and Packaging Waste Regulations 2024 as relevant offences. This enables SEPA to use civil sanctions in respect of these offences. In relation to this instrument, the committee asked the Scottish Government about an apparent error in a reference to the Principal Order. The reference had also not been footnoted. The full detail of the correspondence is set out in the papers published for this meeting. The Scottish Government confirmed this typographical error and that the correct footnote had been misplaced and that it is intended to correct these errors in the signing version of this instrument, assuming that the instrument is approved by the Scottish Parliament. Does the committee wish to draw the instrument to the attention of the Parliament on the general reporting ground in respect of these errors? Does the committee wish to highlight its correspondence to the lead committee, noting that the Scottish Government intends to correct the errors in the signing copy of the instrument? And in so doing, does the committee wish to make clear that it is not expressing a view on the proposed method of correction? Issues have also been raised on 2 linked instruments, the draft Deposit and Return Scheme for Scotland Amendment Regulations 2025 and the Deposit and Return Scheme for Scotland Designation of Scheme Administrator Order 2025. The correspondence in relation to these instruments has been published alongside the papers for this meeting. This sets out the committee's questions and Scottish Government responses in full. The committee's detailed findings will be set out in its report, which will be published in due course, setting out its consideration of subordinate legislation at this meeting. The first instrument would make significant amendments to the Deposit and Return Scheme, which is contained in the Deposit and Return Scheme for Scotland Regulations 2020, which is SSI 2020-154. In summary, in relation to the first instrument, does the committee wish to draw the instrument to the attention of the Parliament as follows? On reporting ground I, that its drafting appears to be defective in respect of the point raised in the committee's question 10, and on the general reporting ground in respect of the points raised in questions 2, 4, 5, 6, 7, 8 and 9. Does the committee wish to note that the Scottish Government has advised that it will take action to address the points raised in questions 2, 4, 5, 8, 9 and 10. The second instrument would designate a body as the scheme administrator to operate the Deposit and Return Scheme in Scotland and would confer functions on it for this purpose. The body being designated is the UK Deposit Management Organisation Limited. In summary, in relation to the second instrument, does the committee wish to draw the instrument to the attention of the Parliament as follows? On reporting ground I, that its drafting appears to be defective in respect of the point raised in question 5.
Yes.
In reporting ground H, that its meaning could be clearer in respect of the point raised in question 7.
Yes.
And on the general reporting ground in respect of the points raised in the committee's questions 3 and 8. And does the committee wish to highlight its correspondence with the Scottish Government to the lead committee in respect of the matters discussed in questions 1 and 2?
Yes.
Does the committee wish to note that the Scottish Government has advised that it will take action to correct the points raised in questions 3, 5, 7, 8 and 9? The committee also asked the Scottish Government questions about the Draft Restitution Fund, Scotland Order 2025, and does the committee wish to highlight its correspondence with the Scottish Government to the lead committee?
Yes.
Under, is the committee content with this instrument?
Yes.
Yeah. Under agenda item number 3, we are considering instruments subject to the negative procedure. An issue has been raised on SSI 2025-137. That's the Public Service Vehicles Registration of Local Services Franchises Transitional Provisions, Scotland Regulations 2025. This instrument seeks to minimise the potential disruption of services and ensure that passengers have a continuity of service should operators seek to vary or cancel local services before a franchising framework can come into operation. In correspondence with the Scottish Government, also published alongside the papers for this meeting, the committee queried an apparent minor drafting error in this instrument. In response, the Scottish Government confirmed that there is a minor drafting error in Regulation 7.1, which it proposes to correct by correction slip. In Regulation 7.1, the reference to paragraphs 2 and 4 should be a reference to paragraphs 2 and 3. Does the committee wish to draw the instrument to the attention of the Parliament on the general reporting ground?
Yes.
Under agenda item number 4, we are considering instruments not subject to any parliamentary procedure. No points have been raised on SSIs 2025-140 and 141. Is the committee content with these instruments? Under agenda item number 5, we are taking evidence from Siobhan Brown MSP, the Minister for Victims and Community Safety, on the leases, automatic continuation, etc. Scotland Bill. The Minister is accompanied by 2 Scottish Government officials. That's Michael Paparakis, the Policy and Bill Programme Manager of Private Law, and Laurie Pigeon, the Solicitor, Constitutional and Civil Law. I welcome you all to the meeting this morning. So first of all, just you don't have to press any buttons, that they'll be undertaken for you. And the microphones will be dealt with. So first of all, I want to invite the Minister to make any opening remarks.
Good morning, Convener, and good morning, Committee. Convener, the Leases Automatic Continuation Scotland Bill implements recommendations of the Scottish Law Commission made in 2022 to reform aspects of the Scots law of commercial leases. This is the 4th SLC bill this session, and a 5th on contract law was recently announced in the programme for government, and this demonstrates our commitment for law reform. Most businesses, large or small, operate at least to some extent from let premises, and the relationship between landlord and tenant is crucial to commercial life in this country. It is important that the law governing the relationships functions effectively, and this bill aims to improve, simplify and update aspects of the Scots law of commercial leases so that it meets the needs of a modern Scottish economy. The bill's principal purpose is to reform the current law of tacit relocation. This is the process whereby a lease continues automatically after its termination date unless one party gives notice to the other that it will come to the end, or both parties agree at the time that it will come to an end. I've listened to the evidence of the stakeholders, including those who have questioned the need for reform in this area and others who have suggested that it may need to be rewritten. I do not agree with these views. The SLC was approached as far back as 2010 by practitioners and solicitors in the area who said the law should be reformed because it was uncertain and was acting as a deterrent to commercial property investment. The SLC's project sets out clearly that the law of termination of commercial leases is inaccessible, uncertain and outdated, and why this is so. Representative bodies of Scottish small businesses and landlords have welcomed the bill and are supportive of it, and no doubt we'll discuss this further in the meeting today. This aside, though, there are a number of technical issues that have come up during stage 1 evidence, and I've worked with the committee constructively in previous bills, SLC bills, and I will continue to do so as this bill progresses as well. And I look forward to answering any committee's questions.
Thank you very much for that, Minister. I'll open the question before handing over to colleagues. So, first of all, can you explain the general rationale behind the bill and how you think the changes proposed will actually benefit landlords and tenants as well as the economy generally?
Thank you, Convener. So, as I said in my opening speech, the law on termination of leases needs reform because it is inaccessible, uncertain and outdated. And the SLC did consider the case for reform, consulting on advisory groups, issuing a small discussion paper, and also engaging with the legal profession, landlords and small businesses. Looking at the evidence that the committee has heard, the legal professionals, faculty of advocates and the Law Society have all agreed that reform of some kind was needed. And the Law Society, for instance, was clear that this was an area that was sufficient litigation and confusion to justify reform. Just on the advantages to tenants and to landlords as well. Currently in Scots law, commercial leases are principally are governed by common law rules. And when the law is not clear or readily accessible, this can result in unnecessary costs to both the tenant and the landlord. And the current legalities can cause difficulty for the landlord and the tenant, which can result in the expense of court proceedings to resolve it. So this bill is looking to simplify and improve that for the tenant and for the landlord. And just to touch on the economic impact of the bill as well, I do believe that there will be some economic benefit as a result of this bill. Most businesses, whether they are small businesses or large businesses, will operate to some extent out of let premises, from manufacturing through to professional services, retail, digital startups and the hospitality sector. And let premises make up 44% of all non-domestic premises that pay rates, and the rateable value from those premises comes to about £2.6 billion. So making the law more certain and accessible can only benefit both tenants and landlords. Thank you, Convener.
Okay, thank you. So with what you've indicated there, particularly at the end, so I think this kind of ties in with my next question. So is this the reason why the decision was made to attempt to codify the law in the way that the bill suggests, rather than, for example, abolishing tacit relocation or only amending parts of the law which, for example, actually weren't working well?
Yes, well, my understanding with codification, it brings all the legal principles of tacit relocation into legislation just to simplify it. It's a very technical legal question that I might pass over to Michael, maybe just to expand on for his expertise.
Yeah, so one of the options which is suggested, Convener, was just to deal with reform part of it and leave other parts to the common law. That perhaps would make the law even more complex, or just as complex as it currently is just now. Landlords, tenants would continue to have to look at the common law from case decisions, legal textbooks, and they would also have to then figure out how that interacts with any provisions that are in statute. So the decision to codify it and bring most of it into this legislation is essentially to make it more accessible and to make it easier for tenants and for landlords to understand what the law is and try and figure out what they should be doing themselves.
Okay, well, thank you. Ross McCall.
Thank you, Convener. There we are. Thank you. Yeah, good morning, and thank you, everybody. This has sort of really interested me because there were various suggestions that the definition in Part 1, Schedule 1, needs to be tightened up. Movables, mixed use of land in rural areas, grazing and mowing leases. There's a big list. So what are your views of the argument made by the Faculty of Advocates and the academics who gave evidence to the committee that having a statutory regime for the automatic continuation of commercial leases and a common law one for agriculture and other leases will create an uncertainty, unnecessary complexity, and I'd be interested in that.
Thank you. Thank you, Ms. McCall, for that question. Just firstly, on the Faculty of Advocates' comments, I know that they've criticised the general approach to the definition of commercial leases in stage 1 of the bill, arguing that it does not make sense to have the automatic continuation for commercial leases and the common law of tacit relocation for other leases. The majority of respondents to the committee's calls for views were, though they were content with the approach, although they had some questions about certain types of leases being included or excluded, and if automatic continuation were to be extended beyond commercial leases, this would be a significant extension and will require extremely careful consideration. And this was not an issue that was raised by when the SLC were consultant on it, or in any written response in the discussion paper preceding its recommendations. If I may, Convener and Ms McQuarrie, I know that there was a few things that's come up in your stage 1 evidence sessions that so that I know that perhaps there's a few that I can touch on where we are just at this stage and what we'll be doing moving forward. Would you like me to touch on those?
Yes.
Okay, so looking at the point that's been raised regarding charity accommodation for veterans and care leavers. So residential leases in general are excluded from the scope of the bill, and sometimes leases such as holiday lets are covered, and the SLC are clear in the report about the reasons why they are not excluded. We know that the Centre for Scots Law raised an issue about leases of accommodation provided by charities for veterans, which are not excluded by the bill, instead, insofar as termination is concerned, and they'd be caught up in the provisions of this bill. So I do intend to review this specific matter, and I will write to the committee ahead of the stage 1 debate. On mixed-use leases, under the current law, it is already possible to have a mixed-use lease. For example, a lease that is regulated in part by agricultural legislation and the common law for the other part. This bill does not create this issue. If there is a mixed-use lease that is entered into after any provisions come into force, then parties or their advisors would simply deal with the issue in the same way they currently do. Parties would have to satisfy themselves whether other legislation applies, and if not, then the provisions of this bill would, and that's what they want to have under the current law. And one way to prevent this would be to prohibit mixed-use leases, but this is likely to affect the flexibility of commercial arrangements, and I don't think that's going to be necessary to do so. Would you like me to move on to? I've got quite a bit.
May I just come back?
Yes.
Sorry, Minister, to interrupt. That's very
okay.
rude of me. But on that particular one, if I can just ask, as we're looking at a bill that is meant to make the law more accessible, I'm seeing a sort of slight contradiction that what we're actually looking at also now is, well, this is what we do currently. This is as it currently is. If we have this opportunity to make it more accessible and better, should we be looking at doing that at this stage?
Yes, so I think one of the things is you'll be aware that the 3 main leases that we have in Scotland are agricultural, residential and commercial, and this bill specifically is looking at the commercial aspect of that. So to widen it would probably be another huge job and another bill, and I know that when the SLC were looking at it, it was specifically tailored for commercial leases. So this is why these are specifically the only ones being covered in this bill. But I don't know if Michael or Laurie have anything further to add to that.
So specifically on agricultural and mixed-use leases, as the Minister has said, this is currently can happen just now, and that's essentially to do with the fact that the definition of what an agricultural lease is contained in separate legislation. So this bill doesn't touch on that legislation. It doesn't look to reform that legislation. What we're solely interested in is commercial leases, and the approach that we've taken in stage 1 is to exclude those other types of regulated leases and focus on commercial leases.
Okay, thank you. And yes, Minister, if you wouldn't mind continuing with some of the other.
Certainly.
Thank you.
Okay, so moving on to the grazing and mowing leases, I know that a number of respondents to the committee's call for view suggested that section 1 of the bill should be clarified with respect to grazing or mowing leases. The provisions in the bill reflect the existing law and the fact that there are currently grazing leases which fall under the common law rather than the agricultural legislation. And under section 1 of the bill, a grazing and mowing lease of less than a year is an agricultural lease and is excluded from provisions of the bill, and they're included in Schedule 1, which deals with leases that do not automatically continue. There currently exist, however, leases, grazing leases that are not defined as agricultural under the current legislation, and these can be dealt with. If not, then the common law of tacit relocation would continue to apply to them after any provisions that the bill came into force. And when we move on to telecoms infrastructure such as wind farms and electricity substations, there's already 2 parallel processes for termination of telecoms leases under the current legal framework. Currently, parties who have to satisfy themselves whether the Electronic Communication Code applies, and if not, then the common law applies. If any provisions of the bill come into force, then rather than the common law applying, it will be the bill's provisions. Members may recall from its work on the recent SLC bills in the idea about specific legislation applying in circumstances where there is more legislation. This is just another example, and I know this is extremely technical, is an example of where the specific code applies even when there is more general provision within the bill. If we're looking at clarifying the application to heritable property, the Law Society have suggested that the bill would be clearer that it does not apply to leases of movable property, and my officials are looking into this, and we will speak to the Law Society to get more information on this specific issue, and I'll write to the committee ahead of stage 1 debate with information on that issue and anything that we intend to take further.
Thank you, Minister. That's all very helpful. Thank you very much. Just a wee additional question, if I may, regarding the termination of leases with telecommunications and the electricity sector. Have you had any contact with the UK Government on this, on how the bill might actually affect that termination?
Personally, I have not sent any communication. I'll speak to my officials. They might have had conversations that I'm not aware of.
We've had no contact with the UK Government about the Telecommunications Code. Essentially, that's because, as the Minister has pointed out, if a lease, if it falls under the Telecommunications Code, then it falls to be dealt with by that Act. So, you know, the bill wouldn't affect that. What it does affect, as the Minister has pointed out, is it affects bills or leases that don't fall within that Act. And rather than the common law of Scotland applying, it would be this bill, tacit relocation, that would apply. So that would be the difference. But essentially, if the lease is covered by the code, it will continue to be covered by the code after this bill comes into force.
That's helpful. Thank you very much, Minister. Thank you.
Thank you. And Jeremy Balfour.
Thank you, Convener. Thank you, Convener, and good morning, Minister. Obviously, we've taken quite a lot of evidence around this, and some have given evidence to say that, in regard to the law on giving notice of in commercial leases, doesn't need to be changed, as the rules are now clear due to the 2021 Radford Trilogy case, and we don't need to do that. What's your view on that opinion?
Thank you. Firstly, my view is that the law in this area does need reform. If I could just go on to the Rockford Trilogy, I know there has been different views given about what that case involved, and some legal professionals have welcomed it, whereas others have not. And for some, the decision brings certainty, but for others, it means that the negotiations between the tenant and the landlord at the end of the lease are fraught with difficulties and uncertainties. And I know that the committee heard from Stephen Blaine, for instance, that the Rockford Trilogy case had added complexity in parties' negotiations when the lease is coming to an end. And the provisions in this bill on giving clear and certain notice, and these should, in my view, be preferred. But going back to your original question, does the bill need to be reformed? Because I know that this has come up several times within your evidence sessions. So I've heard the views from some of the legal practitioners and academics to the committee's calls for views that reform is not needed because the law is well known and works in practice, but the committee has heard from representatives of tenants and landlords that reform is welcome. The Federation of Small Businesses told the committee that small businesses welcome the bill's attempt to modernise the legislation on termination of commercial leases. I know the Scottish Property Federation also has welcomed the bill and supports the bringing together in one place various pieces of common law and statute. And the SLC was approached as far back as 2010 by practitioners and solicitors in this area who said the law should be reformed as it was uncertain and was acting as a deterrent to commercial property investment. So taken all together, I do think the law of termination of commercial leases does need to reform, and this bill, as it stands, does deliver this. But as I've said previously, I am happy to work with the committee moving forward.
Thank you for that. I mean, just kind of developing that slightly, what is your view on the advantages and disadvantages of codifying the law instead of simply updating areas that the Scottish Law Commission thinks don't work, e.g. the current 40-day notice period or the notice provisions in the Sheriff Court Scotland Act 1907?
Yes, I think we sort of touched on this earlier, and I think one of the things with the codification of the bill is it just brings all the different parts together to make it more accessible to tenants and to landlords, and it's all in one place. I don't know, Michael, if there's more that you want to...
I would just reiterate that point that I had made earlier to the convener, and that's if you just update aspects of it and don't look at the wider issue, there is the potential for unintended consequences. The common law, I think, as the SLC told the committee, is uncertain at the moment, and just trying to put sticking plasters on it won't really work, and in fact it could have the opposite effect of making the law more complex and more difficult for practitioners and for laypersons to try and navigate.
Yeah, I mean, just coming on that briefly, I mean, I think everybody agrees this is a technical, difficult area of law, and I think what the Scottish Law Commission tried to go was to make the law simpler, so that particularly landlords and tenants didn't always have to go and seek legal advice in regard to this. I think there's, again, mixed views on whether this actually does simplify the law. I suppose just on that, how do you think the law is now more simple? And do you think, in practice, there will have to be less use of the lawyers getting involved in this because tenants and landlords will be able to do the work without having to use practitioners?
I might pass, if that's all right, the convener to Michael for this and the technicalities.
Yeah, I think it's more simple because it has been brought together into one act or one bill, and tenants, landlords will be able to look up the act and they'll be able to find out what the law is. So I think in that respect it will certainly be simpler. And the fact that we dealt with codification, we're looking at the law in the round rather than just, say, for instance, notice periods. So the whole sphere of the area will be there for individuals to look at. As to whether it might lead to less use of legal professionals, I suspect not. I think if you're going to use a legal professional, you'll use that person whether there's a statute there or not. I think it will be benefit of people who, small businesses, tenants, landlords, who probably wouldn't be able to afford a solicitor either now or after any come into force of any provisions. But the difference would be that those people would be able to look at a single piece of legislation and understand their duties and obligations.
Thank you, Commissioner. I'll leave it there one moment. Thank you.
Thank you for being here today, Minister and colleagues. What is your view of arguments made to the committee that the new rules in the bill on giving notice may be difficult to follow because they're very complicated?
Yeah, so thank you, Mr. Kidd, for that. I don't agree that all sections of the bill dealing with notice are too complex. The current law already lacks clarity and certainty, so both issues with the bill, that will resolve that issue. The bill provides a short list of essential requirements for notice to quit and notice of intention to quit, which offers the flexibility to deal with a wide set of circumstances that are likely to be encountered by the landlords and the tenants in practice. And I know the Scottish Property Federation told the committee that it does not see these provisions being any more difficult to follow than they currently are. Of course, moving forward, if there is any suggestions from the Stage 1 committee report of how things could be simplified, I'm very happy to consider that.
No, thank you. But in following up on that then, what's your view of the arguments made by the Strathclyde Law School to the committee and some others as well, that it would be better to have less rigid notice rules in the bill and to give the parties to a commercial lease more choice on how to serve notice?
So I think this has been raised by a few people to add a bit more flexibility between the tenant and the landlord, and I think this is something that's interesting, and I think it's something that we could explore moving forward. I don't know, maybe the legalities and technical obstacles of that. Michael, you might want to comment on.
I think this may be a reference to allowing tenants a longer or shorter period of notice compared to the landlord. Section 23, read by Section 3 of the bill. It was obviously what the bill proposes just now is that the tenants and landlords have the same period of notice, and it can never be any less or different. The view that there should be more flexibility is obviously an interesting view. It has obviously been raised during the oral evidence and the written evidence, and it's something that we'll be looking at and considering, and we can write to the committee either ahead of the Stage 1 debate or potentially ahead of Stage 2 to signal if we will be doing anything on that.
No, that's helpful, because I was going to ask as well your view on the arguments that have been made to the committee in terms of notice and how that is implemented by both tenants and landlords. Could it be possible that it might be considered that the notice should be the same for both tenant and landlord, that they have the same period of time and the same presentation? Is that possible, do you think? I thought it was being cheered from
yes, I think these are the things that can all be considered. I don't know if there's anything specifically different to the original question. There's like the notice period between the landlord and the tenant. But I think these are things that we will be considering moving forward, and we'll write to the committee about that. Okay,
well, thank you. That's useful. Thank you.
Just before I bring in Jeremy, just on this kind of line of questioning, obviously, so Bill could ask a couple of questions there, but surely with the with whatever process that comes out of the bill, whether there are or not amendments that go forward, surely that it should be clear for any party that's involved in any lease that they know exactly what the implications are for them. And also that they understand kind of what the notice period would be, and also kind of what that process is going to be as well with regards to the ending of a lease. I think that's irrespective as to all the various bits of evidence that we have heard. I think that's it has come across certainly from the evidence that in terms of to get to that point. So there is going to be a clear narrative and a clear set of rules. But you could also argue that it should be a consistent approach. So the rigid approach itself, as proposed in the bill, actually it could work well in that. But business isn't always as rigid as rules are sometimes set out to be. So having that bit of flexibility could be beneficial. But as long as it's everyone understands exactly where they are.
And if I may, Convener, just to add to that, and I think this is one of the main aims of the bill, is to try and simplify and make it easier for tenants and landlords to navigate moving forward.
Jeremy Balfour.
Thank you. I was going to ask this question at the end, but it seems appropriate to ask it now. I mean, it seems clear, Minister, that at Stage 2 you will be bringing forward some fairly major amendments to this bill to change it in the light of the evidence. I mean, one of my concerns now is what I'm hearing from you is the committee won't have an opportunity to scrutinise this by taking evidence because we'll move straight to Stage 2. I'm just wondering at this point, is this bill generally fit for purpose, or does the government need to look to bring these amendments forward before the bill goes forward any further?
So I think it's still the very early stages. You've just taken your evidence session, and I welcome the committee's scrutiny on the bill, and I am going to be taking on board everything that you said. I don't know if I'm going to commit that it's going to be heavily amended throughout. At this stage, I won't be able to tell you that, but there are definitely interesting things that have been brought up that could be advantageous to the bill moving forward to simplify things, which I'm willing to consider. And write to the committee. I don't know if there's something we could do to assist the committee in the scrutiny of this moving forward.
I mean, we'll obviously be able to write to the committee ahead of the stage 1 debate, so the committee will have a chance to consider what the government's going to do. But I don't think that the nature of the amendments that the Minister has said she is going to consider are as drastic or as major as perhaps is suggested. They don't feel particularly drastic or a major change in policy. They seem to be the usual kind of possible drafting changes that have been dealt with previously in SLC bills.
Nothing further.
And Katie Clark.
Thank you very much. And as you know, we've heard a range of representations made to us. So what is your view of the arguments made to the committee which criticise the proposal to allow tenants to give notice orally where there is a lease which has a term of less than 1 year?
I thank Mr Clark for the question. The provisions in the bill on tenants' oral notice reflect the current law as it is at the moment. For those who think that a tenant's notice should be given in writing, there is flexibility in the bill to provide for this. It's open to the parties to agree a provision in the lease that written notice must be given to terminate the lease, and Section 23 of the bill does allow for this. To be clear, oral notice can only be given by the tenant when the lease is less than a year, and so it does not apply in all cases. Leases of less than a year in duration tend to be more informal in nature and do not need to be in writing, and they are of particular value of businesses that need flexibility, for those involved in temporary activities or testing new markets like concessions or food stands, just for a few examples. So requiring tenants to give written notice in all circumstances would be a significant change of the way the current law is, and it was not something that the Scottish Law Commission did consult on. It could also create a trap for small business people who might think that because they've entered into a lease by way of an oral agreement, they can also terminate the lease in the same way, and instead they might find themselves having to continue to let the premises. So I think we should reflect on the possible unintended consequences that a change in law could have here, particularly just for small businesses, just when they're starting out.
So are you satisfied that oral notice is workable?
Yes.
Have you given that thought?
Yes.
And you believe it's workable? Yeah. And what is your view of arguments made to the committee that it's undesirable to change the existing terminology on the law of tacit relocation for this bill? I mean, is there any particular reason why you want to get rid of the terminology, given that it's a tenet of Scots law?
Yes, I think from my understanding, when the Scottish Law Commission drafted this, is to make it more accessible, but also to modernise it as well, and that was with the terminology. I think it was when someone said you could Google it to find out what it is, but in 2025, should you need to Google it to find a Latin word? That's my understanding of it. I don't know if Laurie or Michael have any further input to that.
Yeah, I mean, there's obviously competing interests here. The legislation has to be in plain English, and I understand, I think it was a point put quite forcefully by Dr Brown, that these are good Scottish words and that they should be kept. But, as the Minister has pointed out, tacit relocation doesn't really describe what is going on in a way that automatic continuation does. And we think that, the benefits outweigh the disadvantages of keeping that specific language.
Okay. And what's your view on points put to the committee that vagueness in the bill's language in some places, such as within a reasonable time period at section 5 will lead to litigation, and although less flexible, should be replaced with definite measurable timescales, you know, for example, 30 days. So what's your view on that in terms of vagueness?
Yes, thank you. I think the drafting of this section strikes an appropriate balance and ensures that the law can respond flexibly to a whole array of circumstances that tenants and landlords might find themselves in. The drafting of this section is a reflection of the current common law and will allow courts to continue to apply the law flexibly in many different situations that landlords and tenants might find themselves in a termination of a tenancy. I know the committee heard Dr Brown's view that there appeared to be ambiguous drafting in practice on flexibility. Just on the specific meaning of reasonable period, I know that some stakeholders have suggested that the drafting of reasonable period should be replaced with specific time, either being 28 days or 30 days. And I disagree, and I think that that such a rigid rule cannot take into account all circumstances that parties to a lease might find themselves in. There could be many reasons why a landlord might fail to take steps within the 28-30 days if they're away on a holiday or illness or incapacity, and I know that the committee has taken views on this, and that would result in an automatic continuation of the tenancy, which would be an unfortunate result, especially if the landlord already had a new tenant lined up. So, yes, I think.
So do you envisage that this vagueness is likely to lead to litigation, that we're going to have case law as to what within a reasonable period means?
I might ask the legal section just
well,
on...
that must be something you've given some
consideration
to, Minister. That's something...
My understanding...
I mean, one of the concerns about this whole bill is it's going to lead to more litigation. So, you know, that's
These
something...
it's a political
issue, it's not just a legal issue.
Yes, I know. And one of the things is I get advice from my advisors that they don't feel that, but if there is something that is going to be flagged up, then we will consider it.
So you're satisfied that there won't be litigation?
At this stage, yes.
Okay.
I don't know if you want to add anything, Michael?
Yeah, I could. So specifically in section 5, you know, that's reflective of the current common law. So, you know, if advisors, legal professionals are saying that there's currently not any litigious between tenants and landlords under the current law, then, you know, I wouldn't expect there to be any uptick in litigation as a result of us putting that down on statute. I think it was Mr Bartos who pointed out that it was reflective of the common law. So
you'd fall back on current practice on this occasion in terms of what within a reasonable period means?
Well, I would say that it reflects the current law. It's not current practice, but what happens just now would continue after any provision comes into force.
Yes,
so if there's no litigation on this particular matter at the moment, I wouldn't expect to see an uptick in litigation as a result of that.
So current practice is what happens now. Yeah, yeah. So what's your view of arguments made by the Scottish Property Federation and the Federation of Small Businesses that section 23(2)(b) should be amended so that the parties to a lease can negotiate a clause where the landlord would be required to provide a longer notice period than the tenant? Is that something, Minister, that you've looked at and given
yes,
thought to?
I think this is something that's been brought up just previously
right.
in this 7th session, and yes, it is. It's something. I think it's an interesting proposal and something that we are looking at how we can move forward.
Okay, thank you.
Thank you. And Bill Kidd.
Yep, thank you very much again. Rick, can I ask what your position is on the criticism of section 28? Which allows tenants to withhold payment if the landlord fails to notify them of their UK address, which is unusual, but there you go.
Yes. Thank you. So I think communication between the landlord and the tenant is vitally important, especially when it comes to serving notice and to bring the lease to an end. And sections 27 and 28 of the bill will resolve this issue. I know the committee has heard from the Federation of Small Businesses how, in general, it is a common problem for tenants to get in touch with their landlord, not in the context of just serving a document. And I understand that some respondents consider that withholding rent is disproportionate to the failure to provide a UK address, but a majority of consultees who responded to the SLC consultation on this issue were content with the remedy. Retention of rent is not the sole remedy for the tenant, and of course it is open to tenants not to exercise the remedy at all, or even retain only a small proportion of the rent. Also like to point out that there is a wide range of circumstances in the bill where this remedy cannot be applied. For example, it does not apply if there is a UK postal address for the party included in the lease, or in certain documents registered in the land register or recorded in the register of seizings, and of which the other party of the lease has been given a copy. It does not apply to a body corporate or other legal person with a registered office within the UK. And finally, it does not apply where the duration of the lease is less than a year. This is similar to a statutory provision for residential leases in England and Wales under Section 48(1) of the Landlord and Tenant Act 1987, for instance, applies to residential leases and addresses that difficulties have when the residential tenants do not give postal addresses to their landlord when they don't have a UK address. So I think it'd be a very small minority of people that wouldn't have a UK address that this might come into force.
Okay, well, that makes sense. But do you have a position on the criticism of Section 30, Part 3, which seems to require landlords to serve irritancy notices to a tenant's creditor? So I wasn't sure how you would address that one.
So Section 30 concerns the irritancy of leases and the landlord's need to serve an irritancy notice on the tenant's heritable creditor. And some stakeholders have criticised this provision, but I disagree, and I think it's both workable and of a wider public importance. The responsibility of landlords to search the registers does not place a disproportionate undue burden on them, and the committee has heard, I know, from the Scottish Property Federation, who represent landlords, that they have no issue with this requirement and that it's not much different from the reality of how leases work currently.
Well, okay, well, I mean, I can understand that, but I mean, do you think, what do you think of the suggestion there should be an obligation on the tenant to provide information on heritable creditors to the landlord so the landlord knows who these people are?
So I understand that there has been a suggestion that tenants should be obliged to provide the information about the heritable security to the landlord. I think there are potential difficulties in practice with this. For example, by the time the irritancy is required to be served, the heritable security could have been discharged or assigned. And the Scottish Property Federation, when asked this question, told the committee that while it might be helpful to be given notice, there are nonetheless ways in which they could find out about security, which a prudent landlord would normally undertake before they would serve notice.
Right, okay. So, I mean, basically, though, I think most people think that the tenant, if they do have a heritable creditor, should actually sort of make people aware of this. But landlords should be aware. If they don't, well, they don't. But if they do, what's wrong with them having to alert the landlord to that?
Yes, well, I think it's just a suggestion, and I think that any prudent landlord would normally undertake to do this before entering into a lease anyway.
Okay, well, thank you for that. Thank you.
Okay, thank you. And Jeremy Bell.
Yeah, thanks. What is your view of the arguments made that when transitional provisions in the bill could lead to uncertainty for business who wish to terminate a commercial lease?
Thank you, Mr Balfour. The new law is intended to replace the pre-commencement law underlying a lease, including any implied terms. It's not intended to validate or invalidate the arrangements that the parties have expressed in their lease, and paragraphs 8 and 10 make this clear. Any express lease terms which are carefully negotiated by the parties will be unaffected by any provisions in the bill coming into force. For example, if a lease has an express term providing for a 3-week period of notice for a lease over 6 months, that period will continue to be valid, notwithstanding the fact that the bill provides for a minimum period of 28 days. The alternative, which has been suggested by some stakeholders, is to apply the new law to leases entered into after coming into force of any other provision. This, however, means that one kind of complexity would be replaced by another. For instance, if there was a new law were to apply only to new leases, then the current common law could only apply to old leases many years in the future. And landlords and tenants could be caught up in the future because they don't understand which legal regime applies to their case. So a commencement of the provisions of this bill is by the regulation. So I will ensure that there are sufficient lead-in time for legal professionals and interested stakeholders to make sure that they have all their affairs in orders in regards to this.
Yeah, I mean, I think, again, there does seem to be quite a lot of confusion around this. For example, in the evidence by Shepherd and Weatherburn made to the committee's court reviews, they said it's not clear whether the transitional arrangements apply to existing leases which are extended by tacit reallocation beyond the 6-month cut off period in the bill. So is that something you're looking to bring some clarity to in regard to the legal profession, at least know what you're talking about?
Yes. I don't know, Michael, if you wanted to bring in Regina Shepherd and Wedderburn's comments there.
On Shepherd and Wedderburn's comments, if the provisions, I think they'd given a specific example, and rather than trying to answer it, we're happy to write to the committee. But essentially, if the provisions of the Act have been brought into force in the 6 months had elapsed, then it would continue by automatic continuation rather than tacit relocation. But as I say, I can set that out in a letter for the committee. In terms of the transitionals, as the Minister has pointed out, the suggestion seems to be that the 6-month period would be too complex because you would have the common law running alongside the new provisions. But the suggestion that, from some, that the law, automatic continuation, should apply only to new leases would seem to be a worse position, because it would mean that the old law, tacit relocation, would continue for a lot longer period than 6 months. And as the Minister has pointed out, there could be many years down the line where the lease, the tenant or landlord wants to bring the lease to the end to terminate it, and they may not be able to fully understand, going back to the beginning of the lease, they may not understand whether it should be tacit relocation or automatic continuation. So it seems as though, from our point of view, that having this 6-month period is just a short and clean break that allows, or will allow, legal professionals to and other tenants and landlords to get their affairs in order before the new provisions come into force.
Yeah, I mean, I think there is clarity because everybody knows any lease entered into before the date of the Act coming in falls under one set of rules, and any lease coming into force coming in after the Act comes into force falls into the new rules. I mean, I think that does give pretty certainty, and it's just down to a date. I mean, any person can look at a date and say which line it falls on. I mean, that gives absolute certainty. What has been suggested here with this 6-month kind of hybrid period leads to complete uncertainty for that 6-month period.
So, if we're talking about years down the line, there may not be a lease. The lease may have been lost. The parties, the landlord and the tenants, may not be the original parties and the tenants who actually took out the lease. So there could be many circumstances in which it isn't clear whether tacit relocation or automatic continuation would be in effect, and it would be, it is simpler in our view to have the transitional provisions as set out in the bill.
Okay. Yeah, sorry. Yeah.
Can I just supplement?
Yeah, sure.
So just on that particular question, does the Scottish Government have any figures available with regards to the number of the estimated number of leases that would come to an end, and then obviously then go onto this law if it was passed? as to kind of how many leases would actually be covered by that, but also just on the point regarding the leases that have been lost and then different folk are then involved. Do you have any figures on that circumstance?
I will hand over to Michael, but I have not seen any data on those specific figures.
Okay.
We don't have any figures, no. They're largely private arrangements, so it would be difficult to have any kind of data, I think, on that.
Okay. Okay, thank you. Sorry, Jeremy.
Thank you, Convener. I mean, going on to a very technical point, but one raised by Burgess Sharman was the way notice is defined in paragraph 8, part 2 of Schedule 2, and they say it's pragmatic and that the term intimation should be used instead. Is that something you've considered?
I'm going to pass over to either Michael or Laurie on that one because it's a technical issue.
It's not something that I can say I considered off the top of my head, but I could write to the committee with a view on it, and I can probably get that done maybe before the stage 1 report is due.
That would be helpful. Thank you. And thank you, Convener.
Okay, thank you. And Ross McCall.
Yes, thank you. Me again. Minister, thanks very much. The Scottish Law Commission has consulted on the 1949 Act of the Tenancy of Shops Scotland Act, and it's proposing that the Scottish Government amends the bill to implement this. Now, we've had mixed representations on this. We've had some people in favour of that, and we've had others that are talking about using to reform the Act. So I'm just interested in this. Is it the Scottish Government's intention to use the bill to repeal the Tenancy of Shops Scotland Act in 1949? And if so, could you explain any rationale behind that?
Yes, thank you, Ms McCall. I'm pleased to see the generally positive responses to the SLC's recommendations of possibly bringing forward a Stage 2 amendment to give effect to it, and I welcome the committee's scrutiny specifically on this matter. As members will be aware, the SLC's recommendation of the Tenancy of Shops Scotland Act 1949 be repealed was made in February last year, or this year, and 2 months after this bill had already been introduced. So the Federation of Small Businesses, which represents the kind of Tenancy Act is meant to help, told the committee that they would be a little bit softer about repealing the 1949 Act because of this specific bill. And I am aware that the SLC has itself expressed its hope that the Scottish Government will take forward this recommendation by lodging an amendment to the Leases Bill. And I will consider carefully the responses from stakeholders, and in particular whether there needs to be any other amendments to the bill as a consequence of that, and I will write to the committee ahead of the Stage 1 debate, setting out my views on the repeal of the 1949 Act and bringing forward an amendment.
Thank you. So for clarity, that information you're going to put will also have a response for the Federation of Small Businesses, because they're saying it shouldn't be repealed without putting something else in its place,
yes,
rather than being... So
and
that
we will
all
look
be
into
clarified
all that.
in that.
Yes, and I'll write to the committee further.
Then in that case I have no more further questions. Thank you, Convener.
Okay, thank you. And we've also heard the issue regarding some type of awareness-raising campaign. So what are your thoughts on the arguments that the Scottish Government should actually carry out an awareness-raising campaign on the impact of the bill? And if the Government are minded to do so, kind of what form of campaign, what's the campaign going to look like?
Thank you, Convener. I think this goes back to the point that you raised about raising awareness to simplify things for the tenants and the landlords. And I recognise that the provisions of the bill are important for small business and landlords across the country. The changes that will be made by the bill ensures that the legislation on termination of leases will be brought together and be in one place and be accessible to all. And stakeholders have been clear in their view that they would like to see the Scottish Government raise awareness about these reforms. I am open to working with representatives bodies such as the FSB and SPF to consider what the Scottish Government can do to make sure that tenants and landlords know they might be bringing to the lease to an end. And as for legal professionals, generally the familiarisation of costs of any change in the law will be incurred by those providing training within legal firms, and the provision of such training is typically already provided within the firm's budget, with the cost of maintaining solicitors' legal knowledge being covered by the firm's fee earning income. And we know that Scottish solicitors are required to undertake 20 hours a year of continuing professional development and familiarisation training on changes to the law, which would typically count towards this figure. So yes, Convener, I'm happy to meet with representatives and discuss this and how we can raise awareness moving forward.
Okay, no, thank you. And Katie Clark.
Thank you. And what is your view on the argument that the bill needs clarification as regards the rules on serving notice to trusts and unincorporated associations?
I don't have any information. That's because it's technical. I'm going to pass over either to Laurie or Michael.
Yeah, I think that suggestion came up, and well, having worked on trusts before, they are extremely complex. So it will take us some time just to work through. First off, to talk to the stakeholders who actually raised the issue to try and understand what the issue is, how it works in practice, and then perhaps work through if there are any potential solutions that can be brought forward in this bill. But it's something that we'll be looking to work with them.
Thank you. And would you be happy to write to the committee with the outcome of those deliberations?
Yes.
Thank you. That's very helpful. And what is your view on the argument that the provisions on notice in the Sheriff Courts Scotland Act 1907 should be reviewed more generally and potentially repealed? Is that something that you've given consideration to?
No, I've been just given consideration to this bill here. I don't know if there's been wider scope of work that maybe the SLC have been looking at.
I think the 1907 Act goes wider than just termination of leases. I think part of the issues with the Act is that it doesn't just deal with termination leases. It deals with a host of other issues. We've obviously heard that it can cause problems. There's no it's not a priority in the Scottish Government to look at the 1907 Act in that particular part of it at this time. But I do know that the Scottish Law Commission will be consulting on a new programme for law reform in the near future. I think it's perhaps next year. And if practitioners or stakeholders feel that it is a particular concern, you know, they can make representations as part of that consultation that will go for the programme, and the SLC would consider it.
So you'll have seen the representations that have been made to us, which vary, but there in particular is calls for review of the rules of the 1907 Act. So are you looking at the representations that are being made to us, and is that something, I appreciate the point you're making that it's wider than some of the issues that are within the scope of this bill, but given that it's being raised you know, with us by a number of the stakeholders and individuals and firms of solicitors that have responded, is that something that you are looking at to see if you've got a view on that? Or is that something?
I think it's something we can definitely consider.
It's been raised with us,
Yeah.
so that's the reason that we're asking for a response. So I appreciate that. Thank you.
Okay.
Yeah, thank you. And certainly we've had in evidence a range of detailed drafting suggestions for the bill. And do you have any comments, Minister, with regards to any of these suggestions that have been made by, certainly made by members and also, sorry, made by members of the legal profession and also others who have been in touch with this committee?
Yes, I know that there's been a few suggestions to this committee. I think we have to really go away and consider it with my officials before I would comment on any of those.
Okay. Okay, thank you. Do you have any further questions for the Minister? Martin? No. Katie?
Thank you.
No. Okay. Okay, Minister, is there anything else you'd like to put in the record?
No,
before
thank you
we
very much for the opportunity to come and discuss
Okay,
this.
so thank you. And so obviously we will also get the response back from you, and also there's been a range of commitments made this morning with regards to coming back to the committee as well. So thank you very much for that. Can